All right. Hi, everyone. Welcome. We're starting to let people in from the waiting room, so I'll give it just a minute before we go ahead and get started. All right, I see some people trickling in, so I'll go ahead and get started. Welcome, everyone. My name is Kevin Ryle. I'm the manager of Federal Government Relations at the National Down Syndrome Society, and I'm super excited to be hosting this webinar today. So I'm going to go ahead and share my screen, just go over a quick slides about the National Down Syndrome Society, and then I will turn it off to our financial experts. So again, the title of today's webinar is Planning for Adulthood and Continuity of Care, presented by the National Down Syndrome Society, where we empower individuals with Down syndrome and their families by driving policy change, providing resources, engaging with local communities, and shifting public perceptions. The National Down Syndrome Society has three key areas we focus on: resources and support, advocacy and policy, and community engagement. Our resources and support team, we have a helpline and an info email, as well as we release resources for families to use to help their loved ones. We also have our advocacy and policy team, which is located in DC, where we meet with members of Congress and their staff to promote laws that will improve services and supports for individuals with Down syndrome. And we also have our community engagement team, which is responsible for our scholarships for different programs like the Buddy Walk, the Times Square video presentation, our Athlete Ambassador program, our Down Syndrome Advocacy Conference, which is in 2 weeks, and all the other fun events we have. And as a reminder, like I said, our advocacy conference is in 2 weeks. If you're coming, I'm looking forward to seeing you. And we also have our Times Square video and New York City Buddy Walk this year on September 6th. So I will now pass it over to Mike Walther, who's the founder of Oak Wealth Advisors, to introduce himself more and begin the presentation.
Thank you, Kyle. I'm going to go ahead and switch my screen. Hopefully the technology works for me to do that. And here we go. So very much appreciate the opportunity to come back and communicate with the National Down Syndrome Society membership. I've been in the disability community my entire life. My younger brother, who is now 55, was born with multiple developmental delays and was diagnosed with autism at age 32. So I've been living in the disability community for my entire life and started a firm to assist families like our own, as well as your own, with different planning challenges that come up throughout a person's lifetime. And so today's topic, really planning for the future. What happens when the school bus stops coming? What are those adult planning challenges? What have been the experiences of our clients? That's what I want to share with all of you today. We encourage you to put your questions into the Zoom chat. My colleague, Randy Gillespie, who I'll be introducing in a minute, will be manning and supervising that chat. She'll interrupt me if there's a topic that we should be addressing to the whole group. If it's a quick question that she can answer for just one person, she'll do that in the chat. So feel free to use the chat actively to get your questions and answers addressed. And again, if it's something that needs to be addressed more broadly, we'll make sure we get it covered either during the presentation or at the end. We really want the engagement from all of you to make sure this is the most useful part of your day. So with that, we'll start moving the slides forward. By way of background, as I mentioned, been around the disability community a long time. Our firm won the NAPFA, which is the National Association of Personal Financial Advisors Award for DEI Excellence in 2023 for the work we do in the disability community. We've been honored to get to speak with NDSS for a number of years. And again, love the partnership, love sharing what we know. And again, as you can see there, this is what I do for a living. This is what we love doing, is helping families. My colleague, Randy Gillespie, has got a little more direct connection with the Down syndrome community, having an adult daughter with Down syndrome, who was actually in our office this morning. Loved seeing her. She's also played a significant role with the National Association for Down Syndrome, serving as a support coordinator for families and also working with me on the board for a while, where for a while I was a treasurer of NADS and helped them financially. So our connection goes deep, and we really do care a lot about those with Down syndrome and helping them have the best possible lives. We share those commitments together. Today, we're going to be using person-first language throughout the presentation. This will be a quick slide because it's not going to help you do much other than understand that other people might not want to have communication done with them the same way. We're familiar with that. We know that some people love identifying with their Down syndrome and want to put that kind of first, that, oh yeah, this is my Down syndrome daughter. We're going to take the opposite approach in a group presentation and try to always say the person with Down syndrome. So hopefully I'm not going to offend anyone who wants to be an identity first person, If we're having a one-on-one conversation with you and your family, we'll certainly recognize your preference and do things the way you'd like. But in a group setting, we're going to use person first language today. So what is it that firms like ours do? What should you be expecting if you choose to work with someone or you're talking with people who claim to be a special needs planner? Well, these are really the basic things on the slide. It's really helping them find and keep public benefits and other resources for their loved one, planning for the financial needs of that person as well as the rest of the family, right? It's a dual planning session where the parents need to be taken care of, as does their child. Then creating the structure to either create or sustain independence. We're going to talk about a lot of those things, those adult challenges we find in the Down syndrome community. Then providing additional resources. As time goes on, people's interests, their skills, their abilities, they're going to vary. And so making sure that new resources are available and you can find that from your advisor is a really important element of the relationship. Also, we want to make sure that person who's assisting your family understands how vulnerable our loved ones can be and knows what kinds of supports can be put in place to protect them from both creditors on the financial side and predators on the personal side. And finally, helping a family transition whatever wealth they have, however much money they're able to pass on to the next generation, do that as efficiently as possible, not just from a tax perspective, but also from a speed perspective. There have been times when parents pass away and the money they had set aside successfully for their loved one doesn't get there for months. Well, in times of crisis, we might need the money to move more quickly. So understanding how assets transfer at death and setting up an efficient process that's done tax efficiently is part of what your special needs planner should be doing for you and your family. So with that, let's quickly look at what we believe are the 8 essential elements of a special needs plan. And as you can see, at the core of all of this is good communication within the family and outside the family unit. Today's topics will really focus on the bottom to the upper left. So we're going to start with decision making. We're going to talk about vocational and housing challenges, and we're going to wrap up with the care guide, often known as a letter of intent. So that'll be the focus of today's presentation. If you've got questions about those other topics, you can feel free to reach out to Randy and I after today's session, and we're happily going to address those for you. So as I mentioned, we're going to focus first on decision making. As you're probably aware, when your loved one turns 18, in the government's eyes, they are independent as they're ever going to be. They're their own decision maker. They're a legal entity as an adult. And in order for you to stay involved in their life, there's got to be documents signed to allow you access. You're no longer their guardian as the parent. At 18, they're an adult, and there's no guarantee of access. So understanding what your child wants and what your child needs from you is a really important process in the whole adulthood process. And so let's go through these different topics and figure out which of these might be applicable for your family situation. First of all, if we do nothing, our loved one's on their own, which may be fine for some high-functioning individuals who've shown great skill and development and independence. Maybe letting them make all their own decisions without any supervision is perfectly fine. We typically find in the disability community that's not normally the case. There's certainly outliers who can do that, but for the majority of families, letting the person make all their own decisions without any supervision and no ability to double check or change those decisions can be a risk, right? It's the greatest form of independence. It's wonderful to let the person make as many decisions as they can, but in some cases, they may not understand the elements that are necessary to really grasp before making a decision. And they might be at risk of being exploited or taken advantage of. And the most important thing about letting the individual make their own decisions is this last bullet point, which is if there is no other entity or person involved in their decision-making process, there's no recourse. There's no chance to fix something after the decision's been made by the individual. If they make the decision, everyone has to live with it. There's no recourse, as it's known. So that, again, is the most independence that's available. But we would think in most cases, probably not the most appropriate format for the family. Okay. What's the opposite end of that spectrum? So if full independence is on the left, or maybe the right, depending on how my camera's set up today, and a guardianship's over here. A guardianship is the exact 180-degree opposite of independence. Under a guardianship or a conservatorship, in some states it's called something different. If you're in California, Georgia, and a few other states, it might be called a conservatorship, where the job is for someone else, typically a person, but it could be an institution, to step in and make decisions for the loved one. That's going to provide the most possible protection, because then the person's not legally allowed under a guardianship or conservatorship to make their own decisions. So there's a protection there. Someone else who hopefully understands their needs, their wishes, their desires, can make good decisions on their behalf, but the person, him or herself, is not going to be allowed to make those decisions. And if they're in a situation where nobody knows there's a guardianship in place and they make a bad decision or any decision at all, it can be reversed by law, right? Because they're not legally allowed to make the decision. An example we often give is that my brother, if he was under a guardianship, he could walk into a Chevrolet dealership, cast his eyes on a beautiful new blue Corvette and decide, I want that. And, in tough times, maybe the dealership's like, great, we're going to have a sale here. Go ahead and sign the paperwork. Here's the lease agreement or whatever it's going to be. And he signs all the paperwork, not really understanding what he's signing or what he's committing to dollar-wise. Well, if we find out about that, we can go back to the dealership and say, you know what? Corvette's a beautiful car, but there's no way he should be buying that car. We're going to reverse this entire transaction, and there's no financial cost to the family of doing that. It gets put back in the dealership because the individual should not have been allowed to engage in that contract. They're not legally allowed to under a guardianship. So what the guardianship really does is it transfers all of the person's rights, or in some states, limited rights can be specified within the court system to which rights are being transferred to someone else, but to transfer those rights. And decades ago, people would say, oh, I gave my child the gift of guardianship. The reality is you took away their rights. That's what's really happening there. And so in the broadest sense, a full guardianship could mean things like the person cannot drive, they cannot vote, they cannot enter into any contracts. And in some cases, they can't marry, because at the end of the day, there is going to be a marital contract, right, that's signed. There's a ceremony, but there's actually a contract that's signed for two people to wed. So one of the questions a family has to struggle with is, I really want the most protection possible, but I don't want to take away all of my loved one's rights. So it's important in your state to work with attorneys who work in the area of guardianship and what's called probate, going through that court system, to figure out if a guardianship in general makes sense. Is there a way to carve out certain rights you want the person to keep? Okay, because you're effectively canceling their rights. And if you want to cancel all of them, you want to be as specific as possible what you want changed. And it's important to understand in a guardianship, as I mentioned, it's the 180-degree opposite of full independence. There's a court process. A judge has to make the determination. Typically, parents will go in and say that one or both parents will become the guardian of their loved one. It's possible that the judge evaluates the family situation, determines that yes, the individual should have a guardian appointed, and the judge is the one who makes the appointment. And then that judge might decide, you know what, I don't think the parents are competent to do this role either. So they get assigned what's called a guardian ad litem, which is a legal term basically meaning a guardian appointed by the court. And so it's going to be some other individual who is, in the public guardians department within that community, who's going to have maybe hundreds of cases, hundreds of individuals for whom they're the guardian. Probably not the best situation for your loved one to have someone who's not going to know them very well, making lots of very personal, important decisions for them. So we want to make sure if we go down the guardianship path, we've at least consulted with an attorney. You don't have to use an attorney for this process, but we'd highly recommend doing that, because they can point out for your specific family what risks there might be in the process, help educate you about the conversation you'll have in front of the judge. Because this can also be a difficult time where hopefully you've been encouraging your loved one to be their best possible person, laying out a rosy future for them, promoting all their skills and interests, and really helping to give them a great sense of self-worth. In a guardianship process, the judge is going to ask that individual, can you do all these things? Are you comfortable making your own decisions? Do you want to have someone provide that help? Some judges are better than others, but at the end of the day, the person basically has to say to the court, no, I can't do this. I need the help. And for some people who are proud, that can be a really difficult conversation. So give some thought to the process, make sure you understand it before you enter into it. And so that moment in front of the judge isn't a really bad moment for the family dynamic, right? But that's an important element to understand. Guardianship for some makes sense. We don't think that everyone who turns 18 should have one. It's very specific to the individual's needs and risks, but that's the most protective form of decision-making you can put in place. Any questions about guardianship? Okay, I want to keep moving. The other areas to look at that are relatively newer fall between a guardianship and full independence. The first and most common one is a power of attorney. And the person who assists with the decision-making under a power of attorney document is known as the agent. Many of you may already have powers of attorney in place when you got married. Oftentimes, spouses will name the other person as their agent for healthcare or for property. That allows someone in the event of a healthcare emergency who can't make their own decisions because either they've been injured or they've got some kind of anesthesia that allows them not to be able to make a decision and communicate, to have someone else make important healthcare decisions on their behalf. Okay, that's what the agent can do. In addition, on the financial side, let's assume that I've named my spouse as my agent for property, and I've now got a business meeting that takes me away from when our house is supposed to close, and it's required that all of us sign in ink at the closing. Now, obviously, in modern day times, everything's done digitally and remotely, but if I had to sign something in person and I can't be there, I could have my spouse have my power under of attorney agency, and they could sign on my behalf as if I was there with full power and full rights. So again, a power of attorney gives a named person the rights to either make healthcare and life decisions or financial decisions. There's two different powers of attorney that would both need to be done if you wanted that kind of coverage. Unlike a full guardianship, which would cover all decisions, the powers of attorney are separate for healthcare and for property and assets. So with that, they can be more specific or more broad, and it can either be done immediately, in which case whoever's named is immediately going to have that power, or it can be done with what's called a springing power. With a springing power, it says, if this other event happens, then this person becomes my agent under my power of attorney. And it might be that you have the person trying full independence for a while. And then if bad decisions are made, or if a doctor decides that, you know what, I've been evaluating this person's cognitive abilities and I'm now worried about it, the doctor's letter says, we now want to trip that trigger that now sets the power of attorney in place. There's a triggering event. On the healthcare side, in a typical situation not involving special needs, we typically see it be upon an injury where the person can't make a decision, then the power of attorney comes into effect, but not before that. So in my case, I wouldn't be able to see my wife's medical records at any time, but if she became injured and couldn't make a decision, I'd be able to step in and make those decisions for her. So it allows privacy unless it's needed. But at the time of need, you get springing power to give the ability for someone else to make a decision at that moment. I think in most cases, when we're dealing with a family with a loved one with Down syndrome, we want the power to be immediate. We want mom and dad or one or the other to be able to step in and have that ability to make assistant decision-making with the person right away. But there is an ability to set it only for some future time or for some future event occurring. It's a legal document, no court involved. So I'll typically want to use an attorney to draft these. It's a mostly boilerplate document, not a lot of customization available, but it's got to be signed, and then typically would encourage people to keep a copy. The attorney keeps a copy. And that way, if it's ever necessary, for example, you're going to go in and actually buy that Corvette for your child because you want to make sure you review everything for them, and you've got the right to sign for them if you've got the power of attorney for property. So in that example, you'd walk in with the power of attorney for property. I'm buying the car for my son or daughter. I'm going to go and execute all these documents. You can share all the information with me. I've got that right. Whereas without the power of attorney, you walk in there as the parent, you might be able to sit there, but your child's the one making all the decisions if there's full independence with no guardianship and no power of attorney in place. Hopefully that makes sense. Oh, the last point I should make here on this slide. Unlike a guardianship, which would allow you to reverse that contract decision example I gave you about buying the Corvette, if you're the power of attorney for property and your child walks into the General Motors dealership and buys the Corvette, your family now owns a Corvette. You can't reverse that. So it's a what's called a 50-50 power or a 49-51, where the individual keeps the 51% power because they still have the right at any time to tear up that power of attorney. It's revocable. Whereas under a guardianship, it's not. Only the judge can reverse a guardianship. So power of attorney provides additional flexibility and oversight and support, but it's not necessarily permanent because the individual keeps the right to revoke it. I think in most family situations, the individual with a disability is unlikely to understand they can revoke it and probably wouldn't want to. So probably not a huge concern, but you should just understand how the rules work and move forward appropriately. This is the newest version of assisted decision-making. Not all states have it. It's known as supported decision-making, and it's kind of a watered-down version of a power of attorney. It allows the individual with a disability to name any person as their supporter, that's the title of the person helping with the decision-making, to step in on their behalf, to get information, to access records, to help the individual make the best possible decision. At the end of the day, the individual still has to make the decision, but it gives someone else they're going to name for maybe a specific task or a specific type of decision the right to get the information and access records to help with the decision making, which they wouldn't be able to do otherwise. So if you don't want to go down the route of guardianship or powers of attorney, and you live in a state that recognizes supported decision making, it's another way to go about it. It would not require a meeting with an attorney. There's no legal fees involved to set that up. Virtually all states that have this as a right have a website you access for that state to get that state specific supported decision-making document, which both the person and the supporter will need to sign. So relatively new, no cost to establish because you go find the form online, and it's a little narrower than a power of attorney would be. And to give you a perspective on what states have it available, this slide tells you. If you're in a green state or your loved one's in a green state, those states recognize supported decision-making. The states in yellow have legislation, which God knows what's going to happen this year, but as of the time we made this slide, these are states that have something pending or in process to add supported decision-making as a legal right in their state. The red states don't have anything pending, but we're hopeful. And I know that NDSS and other great organizations are really pushing for greater independence for our loved ones. And I hope that in future years, we won't have to show this slide because every state will have it, but we don't currently. And so if you're in the Southeast, what I just said for the last 3 minutes is probably irrelevant because you won't have access to that kind of a tool. South Carolina is a definite no. The other ones are still in process, but come back in a couple of years and hopefully we can flip this whole thing green.
Mike, a quick question.
Yeah.
Somebody wants to know, can we switch from guardianship to power of attorney or any of the other legal relationships at any point?
Good question.
Yep.
So let me go back at the end of this section. Actually, I'll do it now because we covered the 4 main groups: the independence with full independence, guardianship, power of attorney, and supported decision-making. Guardianship is the only one that the individual can't just change. A guardianship is put in place by a judge. A judge makes a pronouncement, names the guardian. That's in effect until that same judge or another judge reverses it and takes away the guardianship. So just because the person doesn't like the guardianship, just because the parent might not want to be the guardian any longer, they can't just tear up the document and act like it doesn't exist. That's a legal standing for the 2 parties, the person under the guardianship and the acting guardian. So you have to go back through the court, appeal to the judge, say, hey, we'd like to have this removed. We had one example with clients, not in the Down syndrome community, but an older person who had what we thought was going to be a permanent traumatic brain injury and had the spouse named as their guardian. Well, as the person recovered their abilities beyond what the doctors initially thought they'd be able to do, both the individual and his spouse went back to the court, asked the judge to remove the guardianship to give the individual his rights back. The judge denied it. He didn't feel the person had recovered enough and had enough ability to make his own decisions going forward. Very disheartening to the family. They both wanted that change back. So there's no guarantee just because the individual and the guardian want to reverse it or amend the guardianship that the judge will be amenable to that. It's still a process of going through the court to get that done. So that's going to be another expensive process. It takes some time. It may not be a guaranteed ability to change. Under supported decision-making, literally after that one event is done, the supporter relationship goes away. It's more of a temporary status. Powers of attorney are in place until the individual revokes it. And the individual, him or herself, can decide, I want to sign a new one and name a new person as my agent under my power of attorney, or I don't have anybody doing that. I just want to be fully independent. And you also can't have the individual go to an attorney and say, take my current powers of attorney and switch it to guardianship. You have to go through the courts. The judge has to be involved with that process with the guardianship. Hopefully that answered that question. Okay, let's move on to other members of the decision-making team for a family with a loved one with Down syndrome. So the trustee. Oftentimes in the estate planning process, the estate planning attorney is very focused on helping the family pick an appropriate trustee without really giving full thought to the guardianship, powers of attorney, and the other elements. And the family often walks out of that meeting thinking that whoever's named as trustee is going to have all these decision-making abilities. They'll basically have the power of a guardian. Nothing could be further from the truth. The trustee's job is to supervise, manage, and do all the accounting and paperwork related to the trust and the assets in the trust. Think of a trust, if you're not familiar with it, as just another account. It's an account that's going to hold money for the benefit of the loved one. And the person in charge of making all those decisions related to that account, the trust account, is the trustee. So there'll be a legal document, the trust document, that'll name a person or an entity as the trustee. Their job will be to manage the assets, to file the taxes, to communicate with the person who gets the money, known as the beneficiary, as to what their needs are, and to get the bills paid. So that person's going to have a lot of power over whatever level of assets are in the trust. It could be real property like a house or a vacation home. It could be financial assets like stocks, bonds, money market, cash investments. It could be other things as well. It could be like a group of collectibles. Maybe there's a big stamp collection the family has. The trustee may have that if that gets put into the trust to manage that and to give access to the individual if that's what's supposed to happen, or keep it separate from the individual and just sell it off at some point in the future. So the trustee's authority is limited to only the assets in the trust. They're not going to make a decision about whether or not to see a doctor, or which doctor to see, or how often to deal with medical visits, or which medications to take or stop taking. Their role is solely limited to the assets in the trust. But that person should then possess strong administrative, financial, and communication skills. Oftentimes, we'll see families name a loved one. Typically, it's a parent during their lifetime and then often a sibling when they're gone to be the trustee. But we know from experience, not every family has that skill set. It's just not what they do. They may be great at something else, but administrative and financial things are not their best attributes. So maybe we want to find a professional trustee, a corporate trustee, like a bank or trust company that does that work, or a firm that's set up in the state to serve the role of being a trustee. There's actually places like California where there is a group of people whose sole job is to be independent trustees. Okay, that's what their role is. And it's a wonderful group. They're very focused on their roles, but that's somewhat unique to the state of California. Other states, there's individual trustees outside of institutions, and there's certainly the ability to name any individual. One of the things we'll recommend in that process of meeting with the attorney to set up the trust for your loved one is to have several successor trustees. Some attorneys don't push families, in our opinion, hard enough to name more than the current trustees. By law, you just have to have a current trustee, and that's it. We feel that it's important to have successor trustees named and then communicate, as I mentioned in the first slide, the importance of communication throughout this entire process. We want to make sure that future named trustees understand that it's the family's plan that at some point they play this role. Let them ask questions about that. If they don't want to do it, or they don't feel competent to take on that level of responsibility, better to find that out now than when you're dead, right? But oftentimes people have that discussion. They just name a relative to be a future trustee, and then all of a sudden mom and dad pass away and like, oops, this gets dropped in their lap, and they have no idea it's coming, don't know what they're supposed to do. And with special needs trusts, as many of you are aware, they're more complicated than traditional trusts. And there's different rules that impact trustee decision-making with a special needs trust. So we want to have someone who's competent. And in many cases, we'll recommend to families that they hire a professional trustee who works with special needs trusts. The last thing you want to do is have your trustee make an error and then jeopardize your loved one's government benefits because they didn't manage the trust correctly. So all things to think about with respect to the trustee. Their main job, again, as I mentioned, is just the assets in the trust, and it provides a layer of protection. If your loved one gets sued for something, or someone, becomes close to them and wants to take advantage of them financially, the trustee's job as the gatekeeper is to keep that from happening. By law, a lawsuit against the individual is not going to impact their special needs trust. That lawsuit cannot connect to the special needs trust if it's written correctly. And then separately, if the trustee senses there's changes in the distributions and money's being spent much more rapidly, they should be asking questions about, is it all really for the benefit of the beneficiary? Or are they buying stuff for someone else they shouldn't be doing, being taken advantage of? So that's the role of the trustee. And then finally,
Excuse me, Mike.
Yep,
I'm
go ahead.
sorry. Quick question. What happens if a corporate trustee that is named is no longer a company?
Okay, this comes up quite a bit, and this is a really good point to bring up. Even though you might think that the wonderful bank that you've named as trustee is going to be there for the next 400 years, our experience suggests it will not be. We've had many cases where a family's worked with a wonderful trust company in a community and had great relationships with the trust officers. Maybe it's generational wealth, and they just know that's a great group. They name that, and that's the only trustee they've named. Then over time, that trust company gets bought by a regional bank. And that regional bank then gets swallowed by a national or a global bank. And all of a sudden, those great local trust officers have been, sent to the wind. They've all been fired, or they retired, or they moved on to other things. And then you're stuck with a family who's got a 1-800 number to access the information in the trust, to try to reach someone for decision making. And it's a much different experience. So there's a couple of things that can be done here to facilitate that negative outcome not happening for your family. One of which is name successor trustees. Have it in advance that if this trust company goes away, here's where I want to go next. The idea of having multiple successor trustees named. Second, there is a term of art, and I'm not practicing law here, we're not attorneys, but most attorneys can put into your trust document something called a trust protector or a trust committee. That role is not to be the trustee ever. In fact, they can't be the trustee. But that person or group has the power to replace the trustee for any reason if they feel the trustee is not serving the beneficiary as they should be served. So in that example where the great trust company gets bought by two other bigger entities and you lose that personal relationship that was really valuable to the family, the trust protector can come in and fire them and replace them with another corporate trustee they think will be a better service provider. So that's a wonderful thing to have. Doesn't cost you any extra to add that language to your trust document, but it gives the family that protection that if things change with the company they've named in the future, there's an out. It doesn't cost them anything. There's no legal battle over this. We did have one example earlier in my career where it took us 3.5 years to replace a corporate trustee and tens of thousands of dollars in legal fees to get a trustee to resign because legally they had no obligation to do so. And they just fought it through the courts because they wanted to keep the assets and keep the fees, which is sad, but that can happen. So with the document naming a trust protector that can automatically replace the trustee, that trustee is likely to be more attentive to your loved one, knowing that if they don't do a good job, they can be replaced. So it creates a level of accountability that the trustee may not otherwise have. So that's another recommendation. So thank you for the question. The last type of decision maker, this is the most ironic part, is that the person providing direct care to your loved one when you're gone is going to probably spend the most hours with your son or daughter and probably be one of their closest friends later in life. The reality is that caregiving person or caregiving agency has no legal standing to make decisions for your loved one. So even though they might be doing everything from taking them to appointments to helping them brush their teeth, whatever it might be that they're doing, very personal, intimate things perhaps, they've got no ability to make decisions, to change doctors, to change medications, to seek out other things. Their job is to provide care, but it's these other different groups we've named and mentioned today that make those decisions. So it's important the caregiver person or agency communicates well with the trustee, with the guardian or the person with the power of appointment as the agent under a power of attorney. That communication is really essential here because the caregiver is going to best know, hey, he or she really needs this or no longer is using that. And that can be very informative for the trustee for making future decisions about how money is spent, about who's involved and what kinds of expenses are going to be approved going forward. So the caregivers have a big role, no legal standing, and it's essential that everyone's communicating with that person because they'll probably have the most information to share about your loved one. But important to know that just because you name a care agency to provide support when you're gone, they're not going to be doing financial decision-making. They're not going to have any ability to impact the trust directly, other than communicating to the trustee that something is needed or no longer needed. So That's the last element there. Do not assume the caregiver is going to do certain things or take on certain responsibilities because legally they can't, and the agency will know that. Individual may or may not. Let's pivot and start talking about vocational issues. On the very first slide, you saw a picture of me and my brother that was taken around the holidays this year. He's 55 years old now, and we are really blessed that just last month, he celebrated his 25th year work anniversary with the St. Louis County Public Library. I know that that's an unusual circumstance in the disability community. For someone to have a 25-year career with one employer, really rare. We were really lucky. My parents worked very hard. The vocational supporting agencies that they had back in the 1990s were not great. My parents had to do a lot of the work to find that opportunity for my brother to work. Your family might be experiencing the same thing if your loved one's done with their school years. Finding the right employment opportunity with an employer who understands and values your loved one's skills and abilities can be a really challenging matchmaking process. What we want to encourage families to do is to focus on their individuals' skills and interests and passions. If they like doing something, if they care about the subject matter they're working on, they're more likely to be a good employee, to want to stick with that job for a long period of time. And I think the last bullet point's the other one that's probably most important on this page, which is there are lots of benefits that come along with a job that have nothing to do with the paycheck. That's a group of people that over time become your loved one's friends. That's their sense of community. That's their sense of pride and, doing something every day or every other day or whatever the schedule might be. And so having employment brings so much value to someone's life beyond just the financial elements. But it can be tricky. Not only is it hard to find the job, but let's say that the one great place for your loved one to work is a fair distance away from where they're living. It might be difficult to transition in their living location. Maybe they're living at home with you, and the job is 20 or 30 minutes away. In a typical situation where your loved one's driving, not a big deal. Hopefully they'll have a car or access to a vehicle, and they can go to work. As we know, many of our loved ones with Down syndrome don't drive. If that's the case, we need to make sure that the vocational opportunity is accessible to the housing opportunity. And that can be a really difficult thing. So part of that is the planning you're doing now and in the future, so that if you do find a great career opportunity, helping your loved one keep it is important, but also knowing that if that job isn't going to be forever, what else might be in the community? If you live in a smaller location where there are very few employers, that's a really difficult challenge. If you live in a bigger city, hopefully there'll be more employment opportunities if the first one or two don't work out, to pivot to the third or fourth opportunity. But all things to think about when you're evaluating employment opportunities that maybe other people might not have to consider. It's a little bit more challenging, as you know, to find the right fit. You got to think about location access, as well as who are the management team members who'll be interacting with your son or daughter. Do they get it? Do they value and appreciate what your loved one brings to the job? Do they understand the challenges they might have with different roles for that job? And can they be supportive of those things? So finding a great collaborative relationship is really important for long-term success. And then the last element here is understanding that if your loved one's receiving supplemental security income, SSI income, which would be $967 right now if they're getting the full check. If that's their current federal income benefit and they start working, it's going to impact that. Not only will they start losing dollars from the government as they're working, but if they're working at a substantial gainful activity amount, roughly $15,000 a year, they do that for a couple of years, after basically a year, they're going to lose access to SSI permanently because they'll have proven that even though they might have a disability that meets all the federal requirements for being disabled, they have disproven the fact that the disability keeps them able to work successfully. If they work successfully, they will lose their SSI check. So one of the things to think about, and this is often a difficult challenge, is if we've got a loved one with, more likely than not, the ability to be successful as an employee in some capacity in the future, the SSI amount is a great base, and then we're happy to move to the income and opportunities provided by the employer. If we think those disability challenges are significant and will be pervasive, and will probably keep our loved one from able to work successfully in the future, beyond maybe a couple of months where maybe you try it and there's been failures. Although we don't want to jeopardize the SSI benefits, because if we blow through the couple of employers who might be good choices in the local community, there might not be another great choice. And if we manage to get together those successful months of employment, and then the second or third opportunity fails and there's nowhere else to go, now we're stuck with no income benefit from the government because we've proven the ability to work, and no employer to hire our loved one. So a level of challenge that's not typical in the overall population, but in our community of loved ones with disabilities, we've got to be aware of that we want to help our child launch. Tons of reasons to push for great career opportunities, but you've got to be aware if we're on that borderline or on the lower side of that borderline of abilities, it can be really difficult to give up the SSI benefit for the long term. That's worth, upwards of $1 million over the person's lifetime. And to sacrifice that in their 20s can be a big thing to give up. So there's no right or wrong answer. I'd suggest you work with someone who's experienced in this area to help you think through the benefits versus the risks of taking on a low-paying job that might not be for 40 hours a week, that at some point could jeopardize those government benefits. But again, in our opinion, if the person can work, they should work. There's tons of benefits that'll come with that. And in the Down syndrome community, there's so much pride in where they're working. We love hearing from our young people who we meet with, hearing about the love of their jobs and their coworkers. So keep that in mind. It's a difficult thing to navigate, but we want to make you aware of all the different ins and outs related to employment. And why am I advancing later? Next topic is housing. As I mentioned, housing plays into the employment decision, and it can go the other way. Maybe you find the great job and it's in a certain location. Now you need to find the housing that's close to the job. You can go in either direction. One of the big questions we often get is, should our loved one or should the trust for our loved one own the house? Or are they better off renting? Well, I'm not sure that really being in the disability community makes that decision any different than it would be if disabilities weren't part of the decision making. We want to make the best financial decision for the individual and the family. In some cases, home ownership is just a burden, right? Keeping up with the maintenance, the lawn care, the snow removal, whatever it might be, providing the insurance against all kinds of natural disasters. There's a lot that comes with owning a house, all the responsibilities for that. And it may not be the best option. Maybe if a family passes away and they're going to leave the house to their loved one in trust, maybe they're better off selling the house and using those dollars to pay for a lifetime of rent. So there's no clear solution there. It's one where each family should consider, does it make sense to have a property that's owned and maybe get the appreciation and the value of that appreciation for our loved one? Or does it make more sense to rent and have lots of flexibility that if the career opportunities move, the person can move with it? You're not going to move a house, but you can certainly find rent in a new location. The other big question is, what level of support does your loved one need? If they're more independent, maybe just having someone check in on them every now and then to make sure everything's okay is sufficient. And if they're renting, that might be all you have to do. If they own a house, there's obviously all those other elements need to be kept track of. A trustee can do that if the trust owns it, but the house is one of the few assets that an individual can own outright and not be considered to be above that $2,000 asset limit. The house is not counted towards the asset limit for means tested benefits like SSI and Medicaid. So they could own the house. Don't think that's the best opportunity there because, again, the risk of something happening, being sued, if they own it outright, that's their asset. Someone could sue and get the house. If the house is owned by the special needs trust and the person gets sued individually, okay, fine. They're not going to attach to an asset that's held inside the trust. It's protected. So again, there's no right or wrong answer between owning versus renting someplace. We tend to think that renting for most families makes the most sense because it provides the most amount of flexibility. And if you find a new care program that's maybe in a different part of town, you want to be closer to that, you can move your loved one in that apartment they're in to that new location. So again, location flexibility from renting, stability from owning a single location. We'd also suggest that if you're not sure, work with a financial expert in this area to model out what does it look like if we've got the cash resources there, and we're just paying rent. How does that grow and support our loved one versus we take those resources when we buy a house, there's less cash and marketable securities to use for expenses, but now I got a house that hopefully will appreciate, and at some point that house can be passed on to other members of the family. Again, no right or wrong answers here. But the last point, let me get some fluids on my throat here. The last point is, where are they going to live? The reality is, all that talk about owning versus renting assumes they're not living at home. the statistics tell us that between 80 and 85% of our loved ones with Down syndrome are living at home with mom and dad, which is fine until mom and dad pass away. Then the question is, do you keep the person in that specific house they've known their whole life? Or do you move them out to a different house that they own or something they're going to rent? So there's got to be at least that consideration of when we're gone, then what? It might be everything's fine, they're living at home for now, and we all are happy with that. That's totally acceptable. That's a good answer. But what's next needs to be considered and put into your plan. So think through that. And if you're going to have other loved ones in the family, maybe siblings providing some supervision, talk to them in advance. That communication thing is essential in thinking about housing because there's so much that goes into it. Someone probably needs to be involved with your loved one in the future, making sure everything's kept up, making sure that it's still a safe place they want to be living. And so communication along with planning makes housing more successful. Okay. Something else to consider with all the planning we're talking about right now, and that is the potential loss of benefits. I mentioned if your loved one's working very successfully, they're going to lose their entire SSI benefit. Now, they could be eligible in the future for SSDI, a different Social Security benefit for those who become disabled after working. But the supplemental security income benefit they get because they were deemed to not be able to work successfully earlier in life, that would go away. Let's assume they're getting the means tested benefits of SSI and Medicaid. In that example, if we now are going to provide housing for them at home, they're going to stay at home, they're past age 18, they're an adult, and they're living for free with mom and dad, or any single parent, or any relative at all that's providing free housing. They're going to lose 1/3 of that SSI check. They'll get reduced down to roughly $645 this year. Numbers are indexed every year, so it'll be closer to $650 next year. But the reality is they're going to lose 1/3 of their income benefit if they're given free housing. That's also the case if, let's say, mom and dad are gone, the trust owns the house, and they're not paying the trust any rent. So what we'd want to recommend to most people, instead of giving up 1/3 of the check from the government, is have the individual sign a contract, a simple 1 or 2 page agreement that says they're going to pay this amount of money every month for the right to live in their room, have access to common areas, the kitchen, the bathroom, whatever it might be. So the rental contract will specify what services and access they're going to get and how much they're going to pay and for how many years. As long as that contract specifies the rental amount is that 1/3 reduction they're at risk of losing, roughly $325, they're going to be fine. They'll get the full check. Our typical recommendation right now to protect the child for a year or two is to set the rent at maybe $400 or more. That way you don't have to redo the rental contract every year if that 1/3 reduction amount starts to exceed $400. As long as the rental contract is that much or more, they can stay in the house, not lose any of their check from the government, and there's a money transfer from the money they're getting from SSI to whoever the landlord is, mom, dad, some other entity that might own the house. Okay, that's a rental contract. It can be written one of 2 different ways. One of which is traditional rent. I'm going to get this space for this period of time and we're done. Or we've seen it done a different way with attorneys willing to say, we're not going to make it necessarily rent. We're going to say that the person's going to pay their fair share of the expense of living in the house, which could be all the utilities, the maintenance, the insurance, the mortgage payment. They're 1/3, 1/4, 1 whatever of the household group. They're going to pay their share. And if that's done and that amount is specified and documented that it's more than that number I gave you, the $325 to $400 amount, fine. We're not going to have any loss of benefits. But again, without that agreement in place, the individual loses 1/3 of their SSI benefit. Let's talk about the situation where our loved one has means tested benefits. The SSI and Medicaid are in place. And you've done good planning. You've got a third-party special needs trust that will receive inheritances from your family and from others. It's completely independent of the person. That'll fund their long-term financial needs. You also have an ABLE account, another wonderful tool for planning. But your family is very aggressive and you fully funded the ABLE account early in the year, such that there's no more ability to add funds to the ABLE account later in the year. And then later in the year, the person receives a $20,000 gift from someone. Someone passes away, didn't know about the planning, family didn't communicate like Oak Wealth Advisors told them they're supposed to do, and the individual gets $20,000. Well, we can't put that in the ABLE account because they just said it was fully funded. we don't have what's called a self-settled or first-party special needs trust, because we just drafted the third-party trust, which we've named as beneficiary for all those large assets like IRA accounts, retirement plan accounts at work, and life insurance. So in that situation, we don't have a self-settled trust, which is what's required for the individual to move money that they got out of their name and keep their benefits. So the two solutions we've got for that situation, where money comes in, we don't have an easy way to get that put into an account that's no longer a resource for the individual in the government's eyes, is one, an ISM contract. That's just a little term referencing the in-kind support and maintenance benefit that causes that reduction of 1/3. That contract can be with the personal care worker. It can be with an agency that provides weekly or monthly services for your loved one. And what you're basically going to do is, instead of continuing to pay them monthly, you're going to write a contract that says, we're going to give you a one-time payment for the next fill in the blank, 2 years, 3 years, 5 years, whatever it takes to exhaust that amount of money. In my example, the $20,000 gift that arrived, if we write a contract with that care agency for the next 5 years and give them $20,000 at once, and the contract specifies they've got to provide services for 5 more years, we've gotten the money out of our loved one's name legally. We have a contract that shows the services benefiting the loved one. We don't lose benefits. Okay. Otherwise, if we don't do that, the $20,000 is sitting in the account at the end of the month, we're going to lose our SSI check until we get that spent down. And it might take a long time to spend 20 grand if your loved one's already in a comfortable situation. We can't use an ABLE account. We don't have a self-settled trust, don't want to spend 3 or 5 grand to create one. The other thing we can do is, if we don't have any care providers, any people providing that direct in-kind support and maintenance, we can go and have a prepaid contract for something like funeral services. You can go and find the group that's going to provide those services for the family when the loved one passes away and buy them now. Get that money out of their name by buying something in the future in the form of a contract that says when they die, which could be 30 or 40 or more years down the road, they'll get a tombstone, they'll get a burial plot, they'll get services, whatever it might be that your family wants. That'll use up that money. Those are two solutions for making sure we don't lose benefits when unexpected monies show up in our loved one's name. That's a really important thing to do, because oftentimes people lose their government SSI check and don't know how to resolve it. These are all solutions for getting that done. Hopefully that'll be helpful for you and your family going forward. Finally, and this is a really important element, if you do great estate planning, if you put in place things like special needs trusts and ABLE accounts, and you surround your loved one with all kinds of people who care about them, want to help them make decisions, that's perfect planning. It's important, though, to document the individual elements of your loved one in a document so that the future care providers know all the things about them that the family knows. Your loved one may be able to communicate lots of things, but maybe doesn't fully understand all their medications, or understand why they can or can't eat certain foods, or understand why you no longer see a certain doctor in the community. If you think about it, we want the family to have the parents put down everything that they've learned about their loved one that isn't in their estate planning documents and isn't reflected in their financial statements, that's important for that future success of their loved one. It could be, for example, in my brother's case, some unique elements of his autism that cause him to do certain things. Well, certain behaviors might be totally acceptable. That's just an element of how he comforts himself. Other things that he might do might not be. But if that care provider is coming in without a relationship with my brother, they might not know the difference, like which one's acceptable, which one's not. That goes in the care guide. Maybe it's a matter of there's a habit that they have that seems unusual, but if you try to break them of that habit, it makes them very uncomfortable. And now they're going to be difficult from a behavior standpoint going forward. It might cause them frustration if you take away something that they were routinely doing on their own and don't let them do it in the future. So those kinds of things, if we get that into the care guide, eliminates that kind of a challenge in the future. Now, initially, when we started talking to families about this decades ago, it was, paper documents that were copied and shared with immediate family members who might be involved in the future. Today, with all the benefits of technology, using a shared Google Drive, using some electronic version of record keeping that can be shared with passwords, and passwords can then cut people off in the future if they're no longer part of the plan. It can show them limited parts of the plan, but not all of it. It's really up to your family as to what you want to share and with whom. But getting it documented is going to be emotionally challenging. If Randy was leading this presentation today, she would tell you it takes 3 things. Okay, so get out your pens and paper. Final thing to document here. To make a care guide successfully created requires tissues, wine, and chocolate. Randy's told me those 3 things get the document done. Without those, it's going to be more challenging because it's an incredibly emotional thing to prepare for your loved one. It's essentially you looking ahead and saying, when I'm no longer here, here's what someone else needs to be able to do and understand about my loved one to give them the best possible life as if I was still here. And that's really emotionally challenging to ever think about the future when you're not in your loved one's picture.
Excuse me, Mike. My ear thing went out, but I don't know if you mentioned that to the extent that your loved one can also participate in creating the care guide or the letter of intent and being a part of the process, because it is about them. So what are their dreams? What are their wishes? What are their goals? And what are their unique habits and traits? And what makes them happy? And what do they want to do? And one other thing, if there are certain friends, family members that maybe, and I say this because this has happened in my family, there are certain individuals in my family that my own daughter with Down syndrome, who's 20 now, does not really enjoy, just doesn't want to be around. Just, they rub them the wrong way. It's just a thing, whatever. That's okay to document that. The more information that's documented in this guide will just allow for a more, transparent future and more information for the people stepping in to provide these services and supports for your loved one. They'll know exactly what needs to be done. So don't be scared or nervous or timid to really write it all out there, because this is the time to do it when you're alive, when we're alive. And yes, it's chocolate, wine, and tissues for sure.
Thanks, Randy. Again, I think the key thing there is if we're using the right form of process for doing this, whether we're using electronic files and sharing only certain things, there's no chance that that crazy Aunt Susie we want to keep out of our loved one's life is going to ever see it, right? We're only going to share it with those who need to know. But I do think it's important that communication happens, that the family knows it exists, and those who are being asked to provide a role know how to access that information, understand what's being required of them, and can ask questions. And as Randy said, if the loved one, him or herself, can provide input, you want that. You want them to feel like they're part of that process and they're helping set up their future. That's empowering for them. So absolutely have them involved whenever possible. And then what would be in that? So if you need kind of a guideline, you can go to our website. We have information there about it. We actually have a template you can download. Again, I think using electronic form is probably the best path forward, given the digital age we're all living in. We want to have medical information, as I mentioned, failed doctor relationships, medications that had side effects, document that. Relationships, who do we not want to see, like Randy mentioned, and who are the people who are in their inner circle that they really like spending time with? What organizations or individuals? Name them. What are their challenges and abilities? What are the routines? If there's family or religious traditions you want to have maintained, how is some future caregiver who doesn't know your family going to know what those things are? Maybe your loved one can't communicate that effectively. So get it all documented and written out. And then if there's certain stories that gives them great comfort or happiness to have retold, family history stories that they just love, write the whole thing out so someone else can read it to them and remind them.
Or also upload a video, take some pictures, upload a video. Those are, we're a digital age. So do that. If they're not able to speak, if they have some challenges as well, figure out what allows them to participate in this decision-making process for them and their future. So.
Absolutely. And then just if you want to get more information and you're sick of having me talk at you for an hour, you can get much smaller tidbits of great advice on our YouTube channel. There's lots of educational videos there. You can access those. They're typically 1 to 2 minutes in length on different topics, some of which we didn't cover all today. And then we also have a podcast called The Special Needs Voice, available on Spotify. We bring disability leaders together and they share incredible insights about what they're doing with respect to advocacy or new research, or just incredible things they've done in the disability community to really give you that sense that the future is bright, because we think it is. And we think with your loved one pursuing all their dreams and wishes, there'll be even greater opportunities for those generations to come. So we really encourage you to keep doing the wonderful things you are with your kids. And I think you're going to find that it's going to pay that forward to the next generation of people who want to see those examples to follow in the future. With that, we have to put our disclosures up there that say that we might have lied, we might have made all this stuff up. We didn't mean to dissuade you from doing anything you're going to do anyway, but we have to say that. We obviously are in our community with you. We want to help you be successful. If there's anything we can do to answer questions for you now or in the future, feel free to reach out to Randy and me. Our website's got a wealth of free information. You're welcome to go to oakwealth.com and download whatever you want, or click on the links to find more resources in the Down syndrome community. We love to stay connected with you and others. And if you want to be added to our monthly email distribution of our newsletter, which has lots of financial planning tips and specifically disability opportunities, feel free to reach out to Randy. She can get you added to that list. You can always disconnect from that if you ever want to. It's not a marketing piece. It's literally information sharing like we did today. So with that, I know we're kind of at our time limit. We're happy to stay on for a few more minutes if people have questions. You can obviously reach out to us afterwards as well if you want to inquire more about a specific situation for your family or more about our services.
Where's Kevin?
I'm back. Yes, we'll stay on for a few minutes if people have more questions to put in the Q&A or the chat. But again, we'll be sharing the slides with everyone who registered for today's event so they can have access to all the information and also the emails for Randy and Mike. And you can also check out the NDSS website at ndss.org to find our resources and access different emails that we have where you can connect with a member of our team for help. But I want to give a big thank you to Randy and Mike for joining us today and sharing their expertise. I know this really helped everyone listening and helped me as well. So thank you.
Thank you, Kevin. We hope the whole NDSS community is a wonderful year. It's going to be a challenging year. We didn't talk about anything in Washington, D.C., and we're still not going to. But, stay connected, stay informed, and get your people around you to make it the best possible life for your family. Best wishes to everyone.
Thanks, everyone.
Thank you, everyone. Have a good one.